Jurisdiction 102, one of the other fundamental principles students miss in civil procedure studying jurisdiction. What is the difference between federal courts of limited jurisdiction and state courts of general jurisdiction? The good news is the forum fight, as between state and federal court, is in an important sense only of one dimension. A complicated dimension it may be, but it's really only one dimension. I say that because when any case you're thinking of, some complex dispute, some personal injury case, state courts are courts of general jurisdiction. They presumptively have jurisdiction. What you're looking for ordinarily is some reason that the state court can't hear a case, and those come up so infrequently we can leave those aside. Anytime you get a fact pattern, you assume it can be brought, once you determine geography from last video, it can be brought in the state courts in that suit unless you can articulate a reason why it can't. What we are asking, however, is given that fact dispute, given what happened out of court, and given who these parties are, can it be brought to federal court? Federal courts are courts of limited jurisdiction. They don't have inherent jurisdiction. They don't get, with few exceptions, jurisdiction from the United States Constitution. Rather, the question for can I get this case into federal court or can I get it out of federal court will depend upon interpreting some jurisdictional statute, because without it, there's no jurisdiction. All right, so we know when there's a fact pattern, it can get into state court. Can it get into federal court? We don't know. We're going to have to evaluate that. Now, here's the other important point. This is why we do the 102 videos. If we've concluded, under the topics that we will study, that the federal court does have jurisdiction, I could bring this case, for example, in federal court because there's diversity of citizenship or because there's a federal question. That does not mean that the state court has no jurisdiction. What it means is that there is concurrent jurisdiction. Let me say that another way and then I'll say it a third way. A grant of federal jurisdiction tells federal judge you can hear this case, but that is not the same as saying state judge you can't. In other words, if I file a case I could have brought in federal court in state court and you're happy, you don't want to remove the case, we can try that thing all the way through to judgment in state court, and it is entirely irrelevant that there was federal jurisdiction. We didn't do something wrong because a grant of federal jurisdiction standing alone is not exclusive. It just creates concurrent jurisdiction. So we have a choice between those two forums. Now, to say we have a choice is a little bit oversimplified procedurally if we're plaintiffs, because if I'm a plaintiff and I file that case in state court, it's okay. I chose a proper forum, but the defendant will have the opportunity to remove the case. So while there's jurisdiction in the state court, if it's removable, that does give the defendant the option to remove the case. The most fundamental part of Jurisdiction 102 is what it means to have limited jurisdiction from the federal perspective. You need a statute. Federal courts get their jurisdiction from statutes. All right, so the statute, the way I always conceptualize it for myself and for my students, is to say, envision that if you want to take a case to federal court, envision that the judge presiding over that tribunal is going to meet you at the door and say, hey, I don't have any power here unless Congress gave it to me in a statute. So you need to show me your entry pass. You need to show me the statute that authorizes you to bring this case into federal court. When we talk about jurisdiction, many times this nuance is lost, and it causes a good deal of the procedural problems that people have to come in and fix. You remember from civil procedure, or if you're in civil procedure, you can look at your syllabus right now, and you can say, oh, look, there are 3 kinds of federal jurisdiction. No, no, no. There are 3 major statutes that we use a lot. Often the pass that we hand to the federal judge is one of those major statutes, right? The federal question statute. Sometimes you can hand the judge a statute because your case involves a federal claim and say, Judge, look, I'm here prosecuting an action under ERISA, which is a congressional statute. Here I have jurisdiction. Sometimes there's jurisdiction because the parties are of different citizenship, sufficient to satisfy diversity jurisdiction. You hand the judge the statute there, and you say, no, Judge, I'm not here because of my federal claim. I'm here because look at the parties. Here's the diversity statute. And then we know that the removal statute as well grants a certain type of procedural maneuvering to use jurisdiction. But there's more to it than that. And you have to grasp from the very beginning, if you want to master what's going on, that it is not true that a federal court has to have diversity or federal question jurisdiction. It's not true. Federal court has to have a valid statutory grant of jurisdiction. Some recent ones, the Class Action Fairness Act, the Federal Officer Removal Act. Those aren't federal questions. Those aren't diversity actions in the traditional sense, but in each of them, what you have is a party meeting the judge at the door. Imagine the judge meets the party at the door and says, wait a minute, you don't have a federal question. You're right, Judge, I don't. Wait, you don't have complete diversity of citizenship. You're right, Judge, I don't. But what I do have is this other statute that Congress passed where it said if I have a class action and it meets criteria A, B, C, and D, then I can bring the class action, and the judge says, well, that's your statutory pass. What do we need to get into federal court by filing or removal? We need statutory authorization. Now, that filing and removal aspect creates a little bit of a conceptual wrinkle, and that is Jurisdiction 103 on the next video.